This is a presentation by Tabula Lex on the topic of forensic procedure in the subject criminal procedure in first or second year studies of law at Deakin University. The following presentation is merely my understanding of the course material and is not the advice or understanding of a qualified legal professional. This presentation is for demonstration purposes only and is released under a Creative Commons license. All the details will be included at the end of the video. So let's get started with forensic procedure. So the main question, the ultimate question of forensic procedure is whether the forensic sample that has been ostensibly taken is accepted as evidence by the court, and if it is accepted, that'll lead to questions of how to handle the forensic sample after the trial, etc. But if we ground our understanding of forensic procedure in the question of whether a forensic sample obtained is accepted as evidence by the court, because that's what it's all about, ultimately, we'll have a good place to start. So, if forensic sample accepted as evidence by the court, well, how do we know? We refer to the Crimes Act, section 464, subsection 2, to first of all determine whether the forensic sample was obtained by means of an authorized forensic procedure. So what does that mean? Well, first of all, you have to look at whether you're dealing with an adult, that is someone who's 18 years or older, and let's assume that we are. So then we're looking at the preconditions for a police request to undergo a forensic procedure. So someone comes into the police station and the police will ask him whether he is willing to undergo a forensic procedure. Now, the preconditions for their request is that he's a suspect, that he be a suspect, or that they have reasonable grounds for making this request. And what do we mean by that? Well, if the person who has come into the police station is a suspect, it means that he has been charged or summoned for an indictable offence. And simply by virtue of that fact, the police can request him to undergo a forensic procedure. But if he hasn't been charged or summoned, then the police can make this request on reasonable grounds. And what constitute reasonable grounds? Firstly, that the suspect is suspected on reasonable grounds of an involvement in an indictable offence. And secondly, it's a two-part test. Secondly, that the police have reasonable grounds to believe that the procedure would tend to confirm or disprove the suspect's involvement in an indictable offence. So it's not sufficient. The reasonable grounds test, just to clarify, doesn't make it sufficient that the suspect is suspected on reasonable grounds of involvement in an indictable offence. There has to be some further reason, something that the police are further aware of, to give them reasonable grounds to believe that taking a forensic sample from the suspect would tend to confirm or disprove his involvement in said indictable offence. So if the answer to this is yes, then the police can go ahead and request him to undergo forensic procedure. If no, they cannot. And of course, if it fails the first leg of the test, then of course the police cannot request the suspect to undergo forensic procedure. So that's what we mean by the suspect being a suspect, or the reasonable grounds test. So to come back, we've got an adult suspect, and let's say the preconditions have been met. So the police, pursuant to section 464R of the Crimes Act, can make that request. So let's say they go ahead and they make the request. Well, here's where things get really interesting. First of all, when the police make a request, basically there's the easy way and there's the hard way. If the suspect gives informed consent, then they can go ahead, the forensic procedure is authorized. And there are two scenarios where we have informed consent. One is a suspect, and another is a volunteer. So someone who isn't a suspect, someone that the police do not have reasonable grounds to make that request of, but nevertheless volunteers to provide forensic samples, such as in the case of the rape of a woman in a small regional community where pretty much all the men of the town went in and provided forensic samples, and that ultimately, it is reported, helped to convince the rapist to turn himself in. He felt that the long arm of the law was getting out him. So there's the easy way of informed consent, or there is the hard way of basically a compulsory forensic procedure, and that comes in three flavors. We have a senior police officer authorizing the conduct of non-intimate procedure. We have a magistrate's court order, and then in other cases where the police do not necessarily have the authority, they can make an urgent interim order as well. And I'll just fix up that double dot point. Okay, so we'll come back to that in a sec. So let's assume that by hook or by crook, the suspect, the forensic procedure is authorized, and the suspect is to undergo forensic procedure. So there are two main types of forensic sample, two main types of forensic procedure, giving rise to two classes of forensic sample. That's FS, and the definitions provided in section 464 subsection 2 of the Crimes Act. So what's the difference between intimate and non-intimate? Well, intimate, as we might imagine, is a sample taken from a rather intimate area. So a blood sample, a sample of pubic hair, a swab, a sample of saliva, scraping from the mouth, a dental impression. So to put it crudely, an intimate forensic sample is something that they have to stick something in you in order to obtain, whereas a non-intimate forensic sample might be a sample of hair other than pubic hair, or a sample of matter taken from under a fingernail or toenail, or a swab, washing, or sample taken from any external part of the body, other than, of course, the genital or anal region of a male or female, or the breast of a female. So that's the difference between intimate and non-intimate, and assuming that a forensic sample is taken, there are guidelines that the procedure has to be conducted in accordance with, which are stipulated in sections 464 ZA, ZF, and then ZF AAA. And if the procedure is conducted in accordance with the relevant section, then there is another regulation that has to be met with, and that is giving the correct information to the person, that he basically doesn't have to answer any questions. So first of all, has the person been informed by the police that he does not have to answer any questions asked by the person conducting the procedure, so usually a policeman or a nurse or some sort of medical professional or anything like that. And furthermore, has that person been informed that if he does say something, it may be given in evidence. And as long as these two requirements have been satisfied, then there's no problem with section 464Y subsection 1. But if the person undergoes a forensic procedure and says something and wasn't made aware that saying something at the time of the taking of the sample might be used in court, then the prosecution may very well have a problem down the line. So let's go back. So a forensic sample has been taken. All right. And so if a forensic sample has been taken, as we just went over, then it's all good, and we've got a forensic sample that will presumably be accepted as evidence by court. All right, let's go back and say that we don't have an adult. We don't have someone who's 18 years or older. All right, what happens then? Well, we've got two other classes of persons. So if it's not an adult, it's a child between the ages of 10 and 18, so let's say a juvenile. And if we don't have, and if the person in question is younger, then as far as I understand, there's no forensic procedure at all for a child under the age of 10, although the Children's Court may grant an order for a forensic procedure for someone even younger than the age of 10, but it wasn't very clear to me from my notes. But anyway, let's focus on juveniles. So the relevant sections are 464U subsection 3, 464 subsections 7 and 8, and so the first one is that the police may apply to the Children's Court for an order. So the police under no circumstances are authorized off their own bat to take a sample from a child, from a juvenile. They have to apply to the Children's Court, and the Children's Court will consider the matter and refer to these to 464 subsections 7 and 8 for consideration, and then the Children's Court has the power either to make the order or refuse it. So let's say the Children's Court goes ahead and here's the application. Then the application made to the Children's Court is going to be on similar grounds to that of the preconditions, which is that the suspect, the juvenile suspect, is charged with an indictable offence, or that there are reasonable grounds for making this application. And if the court goes ahead with it, then we've got a forensic sample, and if the court doesn't agree with the request from the police, then the police order application will be denied. Okay, so that's pretty much what happens as far as taking the getting authorization for the forensic procedure, and the guidelines for taking the forensic sample are concerned. And just one other question that is worth pondering is the use of reasonable force, and that's a whole topic in itself, but basically from what I read in my notes, the question of reasonable force is very hazy, because it was initially conceived that reasonable force would simply be to restrain someone, it would just to hold someone down, as it were, but it's been used a lot more excessively than was originally conceived by the committee. Now that the authorities have the statutory authority to use what they deem reasonable force, it's not surprisingly quite a loose definition. So let's say the forensic procedure wasn't authorized. Let's say the forensic sample was got by non-authorized means. So in general, that means the sample is inadmissible in court and that it must be destroyed. But there are exceptions. So let's say a sample was got in a way that wasn't compliant with statute. Section 464ZE subsection 2B allows for it to be admitted in court if the accused consents to the admission of the forensic sample. So I assume that would be in the case of some kind of technicality where the accused, for whatever reason, is made to understand that it's technically not an admissible sample, but goes ahead because presumably he's satisfied that or he's confident that the forensic sample will disprove his guilt. I mean, you wouldn't want to accept or allow evidence to be admissible that would incriminate you. So there's the consent of the accused, and if the accused consents, notwithstanding the technical inadmissibility of the forensic sample, then it'll be accepted by the court. But let's say it's not accepted by the accused, and therefore the court can't just go with that. then the prosecution also has the option, pursuant to section 464ZE subsection 2A, to satisfy the court on the balance of probabilities that the circumstances justify the admission of the evidence. And if that is the case, then the court will admit the evidence even though it's technically inadmissible. So the court does have the discretion to admit a forensic sample got by means that were not really permissible according to statute. And there are quite a few factors to take into consideration when the court is presented with an argument by the prosecution that the forensic sample should be admitted as evidence, the probative value of such evidence, reasons for failure, that is, reasons for failing to get the sample by legal means, the gravity of the failure, and whether deprived S of the suspect of significant protection, whether the failure was intentional or reckless, whether the nature of requirement was not complied with, the nature of the offence, whether reception of evidence would seriously undermine other protections in the Act, and any other relevant matters. So, as you can well imagine, there would be quite a lot of work for the prosecution to do if it was trying to get technically inadmissible evidence to be admitted, but there is a provision for such a case in the Crimes Act, section 464ZE subsection 2A. Okay, so let's say that all things considered, we've got a forensic sample. It was accepted as evidence by the court. So once it has been accepted as evidence by the court, we go to then the post-trial handling of the forensic sample. And if the adult was found guilty of the offence, then a prosecution the police, that is, may apply to retain the forensic sample pursuant to section 464ZFB subsection 1. If the accused was not found guilty, and we're still speaking about an adult, then pursuant to section 464ZG subsection 3, the forensic sample must be destroyed if there are no further charges brought to the accused within 12 months. Now, if we're talking about a forensic sample taken from a child, the key question is whether the child was found guilty of murder. And if the child was found guilty of murder, then pursuant to section 464ZGA subsection 2, the forensic sample used as evidence in the trial will be retained. But if the child was not found guilty of murder specifically, but some other crime, then pursuant to section 464GZA subsection 1, the police may retain the sample, but must destroy it after the accused turns 26. And I didn't spot anything in the notes about what happens if a forensic sample is not admitted as evidence, but presumably the forensic sample would have to be destroyed. So that's basically an overview of matters pertaining to forensic procedure, and as you can see, when it's all spread out, there's actually quite a lot to take into account, but it's essentially quite simple. Talking about a particular kind of restraint on the liberty of the suspect, and that the legislation reflects the gravity of taking something that is something from the suspect's person, and there are all sorts of checks and balances built into it, and basically it's just a very specific set of rules for how to handle evidence of this nature and what to do with it after the trial has been concluded. So anyway, that's a presentation from me, Tabula Lex, and I hope you enjoyed the presentation. I hope it helped clarify some of your understanding of forensic procedure and criminal procedure. And if you are interested in my project of legal argument mapping, please check out my blog, tabulalex.blogspot.com. gmail.com. So thanks very much for watching, and I hope to see you soon. Bye.